Right. Good afternoon, everyone. Welcome to our webinar on 6 months of the Procurement Act. Glad you could all make it. One or two items of housekeeping. First of all, I'm in an office, so we have no fire drill planned. If one happens, we'll have to obviously abort and reschedule. We'll cross that bridge only if we get there. Secondly, I'm likely, given the breadth of the topics I'll be covering this afternoon, to spend the whole hour talking. So if you have any questions, and obviously the more questions, the better, do feel free to ask them. But if you could please put them in the Q&A on the webinar, on the Zoom platform, that would be great. And we'll pick them up and circulate responses afterwards. We're also planning to circulate the slides and the recording to you. So without further ado, these are the main items I'm going to talk about this afternoon. There are one or two others as well, actually, interspersed between them, but these are the main ones where we've been seeing particularly interesting things happen over the past 6 months around these topics. So just by way of a very brief reminder of why we're here and how we got here, the Procurement Act is now in full force. It came into full force on February the 24th. Parts of it were actually in force before then, but we don't worry about those. It is now in full force as from that date. It consolidates 4 previous sets of regulations, as I'm sure you'll know, into one new, all-embracing piece of primary legislation. So previous secondary legislation becomes current primary legislation. The Act applies to England, Wales and Northern Ireland to procurement within those 3 jurisdictions, but only to limited procurement activity in Scotland. That is to say, where procurement that might happen in Scotland actually relates to reserved functions rather than devolved functions. Where it relates to devolved functions, obviously the Procurement Act doesn't apply up there. The Act is supported by various other stuff, notably the Procurement Regulations 2024, which give us the mechanical side of our new procurement regime, if you like, setting out, for example, how the Central Digital Platform operates and prescribing the contents of the multitude of new notices that have to be published now under the Act. In addition to the regulations, there are public procurement, there are procurement policy notes, PPNs, the National Procurement Policy Statement, so procurement policy related publications, as well as a comprehensive set of government guidance on the Procurement Act, which I'll come on to talk about. So, first topic, plan, define, procure, manage. What does that mean? Well, the Cabinet Office guidance is split down into each of these 4 phases. Now, the Act itself isn't, so the guidance itself, as well as its extent, because there's quite a lot of it, is actually really handy. It divides a procurement exercise into the preliminary stage, the plan stage, the define stage, only then the procure stage, and once a contract is up and running, the manage stage. And on that manage stage, this is quite new, really. It's a new area of influence for procurement legislation in this country, because some might say that procurement law is perhaps venturing into somewhere it might not really need to go, contract management. But nevertheless, it does to an extent, and we'll see how that applies. Of note, on the contract management side, authorities, as you may know, are required in many cases now to set at least 3 key performance indicators, KPIs, and then to monitor performance of the contractor against them and publish any details of poor performance. All that's new. It wasn't in the previous regime at all. And of course, there are questions perhaps around the impact that might have. Might it make suppliers a bit coy about what KPIs they agree? Might they only agree to KPIs that they can really deliver without question? What is, what are the impacts for their reputation if they don't deliver on KPIs? Might poor performance be much more visible to rivals today under the Act? The answer, I think, is yes. And might the supplier's share price perhaps ultimately be impacted? Well, we are only 6 months in, and obviously in legislative terms, 6 months perhaps isn't that long a time. So time will probably tell. We can't say at the moment, but these are things around certainly the contract management side to look out for as time goes on. National security next is a topic which we've noticed can come up. So the plan phase of a procurement includes a determination of how a particular contract classifies. Is it goods, services, or works? Is it a special regime contract, a light touch contract, or a concession, or a utilities contract? Or is it exempt from the Act altogether for one of the many reasons why a particular contract could be exempt from the Act? And there is, on that latter point, a category now in Schedule 2 of subject matter exempted contracts. And those can include contracts which are exempted on grounds of national security, but of course there are many other grounds for exemption, including subject matter exemption in Schedule 2. Now, paragraph 25 of Schedule 2 classifies as exempt a contract that the contracting authority determines should not, in the interests of national security, be the subject of this Act or a part of this Act. By the way, a contract which a contracting authority can determine is exempt on national security grounds doesn't have to be a defence and security contract, which is another type of special regime contract prescribed by the Act. It's ultimately up to a contracting authority to determine whether, for a particular reason, which will obviously need to be documented very, very well, whether or not a particular contract is exempt on national security grounds. Now, you might think that allows a contracting authority an awful lot of legroom. Well, actually, perhaps it doesn't really, because there is guidance in the guidance document, which is linked on this slide. And obviously, this is a live link when you get the slide. Paragraphs 48 to 59 of that guidance don't define, well, actually, make it clear that the Act doesn't define national security. And that's deliberate. It's designed to keep the concept of national security flexible. So you could be thinking, for example, about contracts which need to be kept secure for, obviously, the purposes of perhaps preventing cyber attacks or whatever it might be. And so before deciding to classify contracts as exempt on national security grounds, yes, it's up to the authority to determine that, but really not before reading that guidance and documenting very robustly the reasons why the determination is that way. Technical specifications is my next topic. And this has come about really as a result of Section 56 of the Act. And I've paired Section 56 up with the Grenfell findings. There's an interesting question here. Will the Act make buildings safer? Now, there has, I think we'd all agree, been a key opportunity here to toughen up the procurement regime in the area of preventing substandard products from landing on the order book. And this really centers on how the rules on technical specifications in section 56 of the Act are framed. And I think there's been a bit of a missed opportunity, and I'll explain why. Now, we know that in the Grenfell matter, there was a lot that was wrong with that particular authority's approach to procurement, and in particular, of course, procurement of the offending materials. The real mischief, though, was that the contractor was able to install inferior cladding to that building. Does the Act therefore go far enough in preventing that sort of thing from happening in future? Well, I don't think so. And I'd be interested in your view, because the Act requires authorities to recognise international standards, which include EU standards, as well as standards in the countries, for example, in which any treaty state supplier under the Act might be established. And it requires authority to recognise those standards as equivalent to UK standards, unless essentially authorities can prove that the international standard is somehow deficient or inferior to the UK standard. Now, my point here is that unless an authority can do that, and there might actually be practical implications or indeed difficulties in being able to do that, an authority might find itself, in effect, forced to accept an inferior standard of product, for example. So stricter UK standards were adopted, but UK contracting authorities may find themselves forced to accept international standards by virtue of the wording of Section 56, even if those standards are inferior, because proving the inferiority of an international standard might not be an easy matter. It could cost time, for a start, money and resource, for example, in deploying expert opinions to decide, or to help the authority decide. And of course, all of that could potentially add a lot of burden to a procurement exercise. Ultimately, UK contracting authorities might find it hard to disprove equivalence in international standards, given notably the wide diversity in different countries' safety regulations. So Section 56, I think, perhaps misses an opportunity to really toughen the technical specification rules, in particular in the light of the Grenfell disaster. A point next to make on this, you may or may not have heard of it. There's a bill in Parliament, the Public Procurement British Goods and Services Bill. It's due apparently for a second reading on the 31st of October. And if passed into law, it would do two things: amend the Public Services Social Value Act of 2012 so as to require authorities to consider how buying British might secure economic and social well-being. So adding another thing to consider into that pre-procurement statutory duty imposed by the Social Value Act. Secondly, it would amend the Procurement Act. And it would do so by requiring contract award notices, and we'll come on to talk about those in a while, to document how the authority has complied with its Social Value Act obligations, which would, of course, then by then include point one, and what effect the procurement thresholds have had on British suppliers in the particular procurement. Now, the question, of course, here is this protectionism? Would it cut across the rest of the Act? What about the duty to treaty state suppliers, which is given prominence by the Act to the extent whereby UK contracting authorities are obliged to treat treaty state suppliers no less favourably than UK suppliers. So I think there are quite a lot of unanswered questions around that one. Debarment is my next topic. The first debarment investigation, which incidentally was launched very soon after the Procurement Act came into being, has been paused. It wasn't or is an investigation into 7 suppliers, which were criticised by the Grenfell inquiry. It was put on hold recently, pending an ongoing criminal investigation into those suppliers' role in that disaster. And the decision to pause, the decision of the Public Procurement Review Service, which of course is part of the Procurement Review Unit set up under the Act, the decision of the Review Service to pause it follows contact from the Met Police and the Crown Prosecution Service saying that the debarment investigations could unintentionally prejudice criminal investigations and any subsequent criminal proceedings. The result then, as of today, is that as of now, the debarment list, link there, is empty. You won't find any names on it at all as yet. Now, there's no word right now on whether debarment investigations will resume or will be completed. We're going to have to watch that one. But as of now, no one is on the debarment list. Next topic, conflicts of interest. Now, authorities under the Act have to contend with a somewhat toughened up set of rules around conflicts of interest, not least in order to give confidence to suppliers that suppliers are bidding in procurement processes which have integrity. And of course, you'll perhaps be thinking here back to Section 12 of the Act, where one of the objectives of procurement in the new era is for authorities to act and be seen to be acting with integrity. So as part of that, the Act has tried to strengthen authorities' duties around conflicts of interest. Sections 81 to 83 are the sections in play here. Authorities have to exclude a supplier if there is no way to manage a conflict effectively, for example, through mechanisms and devices such as information barriers, separation protocols, firewalls, ethical walls agreements, and so on and so forth. However, there is old case law which essentially said that exclusion of a supplier, so barring a supplier from bidding on the basis of a conflict of interest, should really only ever be seen as a last resort. And there's no reason, I think, to interpret the Act any differently. So I think that authorities shouldn't get overly trigger happy about excluding suppliers, but should instead make absolutely sure that they do investigate whether there are ways, and indeed, if so, implement those ways to manage conflicts of interest effectively through the mechanisms and devices shown on this slide. Do the rules, though, around conflicts of interest go far enough? Might the Act's concept of the conflicts of interest, as set out in 81 to 83, be a little bit too narrow? Section 81 actually appears exhaustive. So remember, in the Act, I don't think we necessarily have to interpret it purposively in the way that we did the previous EU-derived rules. Section 81 says there is a conflict of interest in relation to a covered procurement if a person acting for or on behalf of the contracting authority in relation to the procurement has a conflict of interest, or B, a minister has a conflict of interest. Now, interest includes personal, professional, financial interests and can be direct or indirect, as you probably expect. But if Section 81, if the italic section there is exhaustive, as indeed it appears to read as though it is, where does that leave other people? So, for example, incumbent suppliers. What about bidder to bidder conflicts? Conflicts perhaps involving a supplier who might be a prime bidder in one bid, but perhaps a subcontractor to another bidder on the same procurement. What do we do then? It seems that the Act actually leaves questions like that noticeably unanswered. What about personal relationships also between a bidder's officer and an authority officer who might just not happen to be involved in the procurement, isn't acting in relation to the procurement? So I think there are going to be topics here which will warrant and may end up being subject to further investigation and who knows, challenges in future months and years. Wait and see. Now something about the competitive flexible procedure. So CompFlex, as it's often affectionately now referred to, has in our experience been quite widely taken up. We've seen rather more CompFlexes than open procedures, for example, under the Act. CompFlex has been taken up, for example, in light touch procurements that we've seen and in others. And reactions to the new procedure have, I think it's fair to say, generally been very positive. Seems that it's especially useful, and indeed it's intended to be, for tailoring to be suited to the aims of the particular procurement. In other words, we've moved away from one size fits all, and we now have an onus on contracting authorities, or perhaps an onus and a freedom for contracting authorities to design their procurements to suit the ends of the procurement. So this, for example, can allow for stages such as presentations, which we're seeing, interviews, which we're seeing, demos, site visits, and so on and so forth. And all of that, I think, is welcome news to contracting authorities, at least who, for example, might be running a procurement for something to be installed in a building or for works, but of course also for others, ICT, for example. Contractual authorities have to ensure, having said all that, that the procedure is a proportionate means of awarding the contract, having regard to its nature, complexity, and cost. And again, that is perhaps to be expected. Proportionality is everything. It always has been, and certainly an overly complex or indeed an overly simplified procurement might not suit the ends ultimately of the procurement and the contract. There is the flexibility to limit supplier numbers, a bit like a restricted procedure or competitive dialogue under the old rules, generally or indeed in respect of particular rounds or processes. However, an authority mustn't let back in suppliers who were previously knocked out. It's not that flexible. Or let in new suppliers part way along the procurement. It's not that flexible either. But authorities can exclude suppliers who are non-UK and non-treaty state suppliers. So anyone from a total third country can be excluded as part of a competitive flexible procedure. Useful. Transparency next. Interesting here. There's a big difference in the Act between what it says about transparency and what the previous regime did. So Reg 18 of the previous regime, the PCR, said contractual authorities shall da-di-da-di-da act in a transparent and proportionate manner. So transparency has long been a pillar of public procurement, permeating every aspect of it. Does that remain the case under the Act? Well, yes, actually. But how? How does transparency play out in the Act? Well, transparency, if you ask me, just got more transparent. But the Act has managed to pull that off without actually using the word transparent even once. The only time the word transparency is used is when referring to a transparency notice. So how does the Act basically ensure transparency without saying the T word? Well, for a start, one of the objectives of procurement under the Act is sharing information for the purposes of allowing suppliers and others to understand the authority's procurement policies and decisions. That's in section 12. So with a strong hint there, it's all about sharing information. Does that mean it's straightforward? Well, whereas in the PCRs there was an absolute obligation to act in a transparent manner, shall act in a transparent manner, Reg 18, we now see a more muted, perhaps, obligation in the Act. In carrying out a covered procurement, a contracting authority must have regard to the importance of sharing information. Well, that has me scratching my head a little bit, because what does have regard to the importance of mean? Does be transparent? Has be transparent just lost a bit of its vavavoom? Well, actually, not really. The Act doesn't use the word transparent, nor does it frame an obligation to act transparently as an absolute requirement. What it does do is to require authorities to publish and indeed to keep on publishing. It introduces no fewer than 14 new forms of public notices, most of which are mandatory most of the time, as well as requiring publication of various contract data and indeed contracts in particular situations. Now, there is a useful bits and bobs section, which I won't talk to in this hour, at the end of this presentation, so you'll see it when you get the slides. But in it, we've included a visual aid on the various new notices, so you'll know what's required and when. So that's transparency. Direct award and modification, next topic. So there is more scope under the Act for direct awarding. We're perhaps happy to see. There's clarity on when direct awards can be made. Contract awards, of course, by default, have to follow a competitive tendering procedure when the procurement is covered, unless a direct award justification applies. So there is, in the Act, a Schedule 5, I think it is, which sets out the situations in which direct award is allowed. Now, the Act also allows for what we might call crisis direct awards to protect life, safety, or public order. And those direct award grounds can arise when regulations are prescribed and made by a minister for the purpose. So, for example, if there is a pandemic or some sort of national emergency, meaning that a whole lot of contracts suddenly need to be directly awarded, regulations can be passed allowing those direct awards, and those then are added to the direct award grounds for the purposes of the Act. It's not necessarily the case that if and when those regulations or any such regulations were made, they'd be set in stone forever. They probably wouldn't. The government would have to keep them under review. Happily, no such regulations have yet been made. And we hope, of course, that they won't for a long time. Now, above threshold direct awards have to be preceded by a transparency notice, almost without exception. There is an exception, I think I'm right in saying, for something called user choice contracts under the light touch regime, but it's pretty much without exception. Authorities can, however, even when making a direct award, when contemplating a direct award, still do various things before they do so in order to ensure value for money. For example, price comparisons, benchmarking, or whatever it might be. And we probably shouldn't understate the importance of that, especially given the Section 12 objective, of course, which is which includes value for money, ensuring that value for money comes about through public procurement. So I think perhaps a message for authorities: don't just jump to make a direct award. Think about what might usefully or indeed of necessity need to be done prior to a direct award in order to ensure that the objectives of the Act are still being fulfilled. Modifications, contract changes, as they're called under the Act, justifications for unprocured contract changes under the Act are thankfully now better aligned to the direct award grounds. Under the old rules, there was always a bit of a mismatch between the two. The rules of direct award were a little bit different from the rules on modifications. The safe harbours were different, but they're more aligned now. There is a new one under the Act, a new ground for change, justification, safe harbour, which is materialisation of a known risk. What's that all about? Well, it's really sort of saying, well, if we know that there is, we know that there is a risk of a particular thing happening at some point during this contract, and we know what the risk is so that we can articulate it in the contract. Then, further down the line, if that known risk, which has been mentioned in the contract, were to materialise, we could make the necessary variation to the contract to react to it. That's essentially what it is. I remember seeing some comments from a client on a document where this was actually being discussed and debated, and there were lots of comments about sort of asteroid attacks and things like that, which probably might be slightly above and beyond, but nevertheless, you hopefully get the gist. However, there is, around modifications, contract changes, much more transparency now. Contract change notices have to precede the implementation of any changes. And of course, there could be quite a knock-on effect there. It's likely to raise the stakes considerably, and could mean that contract changes won't escape under the radar, like I think many contract modifications under the old rules used to do, and they might attract more legal challenges as time goes on. We only have one notable case at the moment, James Waste, an Essex County Council, around a contract variation. Time will tell, but the numbers of legal challenges based on modifications to contracts procured under the Act might well shoot up as time goes by. Now, assessment summaries. So we've got to the end of our procurement. We've decided who's won and who's lost. It's time now to break the news to the bidders and actually to the world at large, as you'll find out. Now, under the pre-Procurement Act regime, so the PCRs and the other sets of regulations, this was the information that needed to go into a standstill letter. Okay, so this was Regulation 86 for the public contracts regulations. And of course, for procurements that are still in play under the old regulations, it's still the standstill letters which are governed by Regulation 86, which need to be sent out. And this is the information they have to contain. But under the Act, things have changed. And rather than standstill letters or contract award notifications or whatever we might have been wont to call them, we now have assessment summaries. So at the end of a procurement, which is governed by the Act, we have to issue assessment summaries. So if we've been used to standstill letters containing certain information, and perhaps some of us have had the unhappy task of drafting lengthy comparisons between an unsuccessful bid and the characteristics and relative advantages of a successful bid, thankfully we're spared quite a bit of that work now with assessment summaries. And there's a difference. Suppliers, as well as contracting authorities, will see a difference in how the information is going to be presented in processes governed by the Act. So the feedback at contract award stage, so prior to the standstill starting, the feedback has to contain an assessment summary concerning the bidder's tender. In other words, the scores, and there's quite a lot of information. We'll see that in a moment. It needs to go in there. A copy of the preferred bidder's assessment summary with any confidential information redacted from it, and potentially additional information where relevant to the contract award decision. Now, does the standstill period get triggered by sending out the assessment summary in the way that the standstill period gets triggered under Reg 86 of the PCR by sending out an award decision notice stroke standstill letter? Well, no, it doesn't. The standstill, which, by the way, isn't 10 calendar days, but which instead under the Act is now 8 working days, that standstill period only starts with the publication of a thing called a contract award notice. So this is one of the 14 new forms of notice, which I mentioned earlier. This is a contract award notice. So we've sent out our assessment summaries, we've pushed those out to the bidders, but standstill only starts when we publish our contract award notice. If then there is no challenge within the standstill period, the contract gets entered into, and then after that, a contract details notice has to be published within 30 days, or I think it's 90 days if it's a light touch contract. So what do assessment summaries have to contain? So you'll have seen the sort of atomium-shaped diagram on the previous slide, but one, in relation to the requirements under Reg 86. This is the corresponding diagram for assessment summaries under the Act. And by the way, the contents of an assessment summary are actually listed out, not in the Act, but in Regulation 31 of the Procurement Regulations 2024. That's the set of regulations which, as I said at the start, really sort of set out kind of the mechanics and some of the detail around the workings and the operational side of the Act. These are the requirements. Obviously, there's an assessment summary for the most advantageous tender, the MAT, and that information with, as I say, confidential information redacted from it has to be issued to the other tenderers together with the equivalent information on their own tender when assessed, where assessed, of course, against the award criteria, plus any other explanation of why they didn't win, which might, for example, be because they were adjudged to have submitted an abnormally low bid, or perhaps in an open procedure they failed to meet the conditions for participation and so were not successful in having the remainder of their bid evaluated. Likewise, perhaps in a complex. Issue to all tenderers has to be simultaneous, and then only when the assessment summaries have been pushed out does the publication of a contract award notice then follow. So what are the consequences of assessment summaries? Well, first of all, they can be bulky because there's quite a lot of detail that needs to be set out in them. Have a look at Regulation 31 of the 2024 regs. Because of that, they might be best dealt with, depending on your procurement and your numbers of award criteria and sub-criteria, by the way, all of which have to be included, might be best dealt with in a spreadsheet rather than trying to do so in, for example, a Word document or a PDF. Unsuccessful tenderers see all of the information about the winning tenderer, bar the confidential information that the winning tenderer itself sees. But despite that possible bulk, The upside is that the relative advantages, the whole relative advantages thing has gone. There will be no need, when they come to prepare their assessment summaries, for authorities to spend ages, loads of time, drawing up narrative comparisons of characteristics and relative advantages of the successful tender as compared with the unsuccessful tender of the recipient receiving a particular notice. That aspect should save contracting authorities a lot of time. And of course, it's then up to suppliers to put the two together and to work out from that why they've been unsuccessful. Contract award notices, I said I'd come on to this. And of course, it's this that triggers the standstill. However, there's a wrinkle, because the intention to award the contract is published via the contract award notice, not the fact that a contract has been awarded, because it's pre-contract now. But it's not just published to the tenderers, it's published to the whole world. It's published on Finder Tender. And that means that anyone, and not just the unsuccessful tenderer or tenderers, could, in theory, object to the award during a standstill period before any contract gets signed. Would a legal challenge from a non-tenderer actually trigger an automatic suspension, as would a challenge from a tenderer? Well, potentially, yes, it could. And this, again, is new. If the challenger is a supplier, so somebody who might have wanted to bid for this particular contract, then that supplier could see a contract award notice and decide to mount a legal challenge. So as long as that challenger is a supplier to whom a statutory duty under the Act is owed, i.e. a UK or a treaty state supplier, and as long as that supplier has suffered or is at risk of suffering loss or damage, which it might be able to establish, then presumably it has standing to challenge. So this could include, for example, a supplier who thinks that what's been awarded, as detailed and described by the contract award notice, isn't what was originally advertised, that there's been movement between the beginning and the end of the procurement. And that, for example, if the contract award notice had indicated a result that was foursquare with what was advertised, then that supplier would have participated. And it only didn't because it didn't think that what was going to be awarded is what is now about to be awarded. And therefore, the supplier could say that it has suffered or is at risk of suffering loss or damage as a result. It seems to me that this is entirely plausible. So automatic suspensions could be taken up by a lot more entities, potentially, at least in theory, than merely by suppliers as under the previous regime. Incidentally, also, contract award notices could be challengeable if they don't contain enough detail. I do think that there is case law from the UK, the Faraday case, which related to a voluntary transparency notice under the old regime, which might potentially stand a chance of getting picked up if any of the new notices prescribed by the Act don't contain sufficient detail to allow a reader to see properly and clearly what's going on and indeed everything that's going on. So we would counsel against too little detail in a Procurement Act notice. What else has to be published on award? Well, after award, contract details notice. So alongside the contract details notice, which I think has to be published 30 days after award, authorities also have to publish a copy of the contract if its estimated value is more than £5 million. Now, the Publication of the contract doesn't necessarily need to be simultaneous with the contract details notice, whereas the contract details notice is 30 days after contract award. The publication of the actual contract, again with any redactions done, has to be within 90 days or 180 for light touch contracts. Incidentally, I think for a contract details notice, it's 30 days after contract signature for a fully regulated procurement, but 120 days, I think, for a contract details notice for a light touch contract. I think that's right. Anyway, it's all there in the Act and regulations. Key takeaways then. Well, much more visibility. I think the transparency has made it, whoopsie daisy, transparency has made it into the Act in a big way. It's essential to ensure that any justifications, processes, and explanations really given for anything are robust. There is now a new and more granular format for feedback in the form of assessment summaries. And of course, as part of that, it might be necessary to get on board a wider spectrum of staff when preparing and compiling feedback. Perhaps more functions will need to be involved in order to get the feedback right in an assessment summary than has previously been the case. A word or two now on contract management. So there are various facets to contract management as already signalled under the Act. Firstly, for individual contracts valued at £5 million or more, authorities must do these things and also publish these things. So there's quite a lot of visibility now around contract management, and we're already finding ourselves asked to get involved in advice on what is involved in these various aspects. So we'll see more of this going forward and a lot more of it. Interestingly, not only do contract changes and contract variations and direct awards need to be published as previously explained, but also contract breach, details of persistent poor performance, contract terminations for whatever reason, whether for breach, on discharge, or indeed just on expiry, and also terminations of procurement processes without an award. Those also have to be, or details of those with, I think also reasons have to be published. So the whole transparency thing has gained a lot of extra wheels under the Act. What might that mean? Well, we've already hinted here that suppliers looking to limit the agreed KPIs to the bare minimum. We may well see that. I don't know whether any of you might already have seen that. Suppliers wanting control over what gets published. We might see that. Suppliers only agreeing KPIs that they can easily meet, and being difficult about KPIs that they can't or that they don't think they're going to be able to meet easily. So much more debate perhaps between suppliers and authorities pre-contract around suitable KPIs to include. Published performance levels might damage a supplier's reputation, hence the caution that we might see from suppliers as mentioned above. And again, early days at the moment, but I think time will tell on that. My next question was, can old case law be used as a guide to interpreting the Act? Well, first of all, there is some good case law out there, including UK case law already. There's also EU case law, which might still be persuasive. And so there is potential for courts still to follow it. And these are some of the topics around which there is good case law. I haven't listed out all of the case law because if I did, it would be quite a long list. But there is quite a bit. Now, how then might that old case law translate through to the Act? Well, it's clear that in some respects, case law has been overwritten by the Act because of the differences in the way the Act approaches certain things and attacks certain topics. That probably does, in effect, extinguish some of the old case law, but by no means all of it. And I think that it is true to say that where the underlying objective of a particular provision of the Act is the same as that of the relevant bit of the law that it replaces, then there actually seems to be no reason at all why that case law should not continue to be at least persuasive or even binding. So, for example, there might be case law around abnormally low tenders, for example, that we might find being applied. There are perhaps others too. There's quite a lot of case law, admittedly quite old and not all saying the same thing, around the old chestnuts of what is a contracting authority, what is the status of bodies that we're not really sure whether they're contracting authorities or not. Might those debates still continue and that case law still be arguably relevant under the Act as it was under the old regime? And I think the answer to that is yes, to be honest. There may, having said that, of course, be a distinction between old UK case law and old EU case law. So old English case law, specifically, could, where it's on topic in relation to an issue under the Act, be binding. Case law which has previously been persuasive, so for example, Scottish case law, that could still be persuasive under the Act. EU case law, once binding, could still be persuasive under the Act where a point made is on topic as regards the Act. What support does that view have? Well, we have heard from certainly one of the leading commentators, one of the very leading commentators, who is of the same view. And so it's, again, I think time will tell once we start seeing challenges coming through following procurements under the Act or in response to matters arising under the Act, whether or not the old case law is invoked. But it might be, and so again, it's another one to watch. So those were my main topics. Is there any other news that we want to talk about? Well, yes, there are a couple of bits. To any of you who are familiar with or use the Crown Commercial Service Model Services contracts, those have now been updated in the light of Procurement Act. And we've included here some links to all three of them. You'll be pleased to know, if you haven't delved into them already, that all of them come complete with guidance. And the guidance is there for you to look at. And you can access the guidance alongside the contracts via these same links. Okay. Consultation on further reform is the other bit of other news. So just when we thought that everything was bedding down and we could just look at the Act that we've got and go to bed on it, well, we can't, because further reform is being talked about. There is a consultation, or there has been a consultation. It ended on the 5th of September, and I noticed this week that the Competition and Markets Authority has weighed in with quite a long response to it, which is worth reading, I think. Really, in relation to how public procurement can actually be a tool to shape markets, which is an interesting and valid point, I think. So do have a read of that if you would like. But the possible further reforms which the consultation covered or invited views on were really built around these three policy goals. First of all, supporting, giving further support to SMEs and social enterprises, VCSEs, in terms of whether there ought to be greater targets for increasing procurement spend with those types of organizations, prompt payment, and also around people-focused services, the first area. Secondly, supporting national capability, in particular, whether there ought to be a standard assessment undertaken by contracting authorities on whether, for example, a particular requirement could be delivered in-house, should be delivered in-house, or should instead be outsourced. And also a priority around a policy goal of supporting good quality local jobs and skills. So three fairly laudable policy goals, I think, in there. What I did notice, though, was actually no mention of that bill, the British Goods and Services Bill, the one I talked about earlier, in it, which seems a little odd, but anyway, I understand that the second reading of that bill is due on the 31st of October 2025, so in not many weeks' time. If you'd like to view the passage of that bill, then there's a link to the House of Commons website there, and you can see how it's going. And finally, I thought I'd just leave you with this. How would William Shakespeare have written about the Procurement Act? Well, you'll be pleased to know that I'm not going to recite it now. I'll leave you to look at it, have a chuckle at it when you get the slides. I can't, I'm afraid, take the credit for any of this. Whoever it was or whatever it was that wrote this, I think it's actually quite good. So I do recommend it to you. And of course, for further help, you know where we are. If you are not already aware of or haven't already seen or tucked into our Procurement Act toolkit, then obviously do check it out. The link is right there. And if you alternatively have a question which you'd like to take up with me or one of our team, links to our team members are in the toolkit, and a link to my email address is right there. In terms of questions, by the way, the useful bits and bobs are here at the end of the slide. This is the visual on the Procurement Act notices. And this is a visual really just offering you guidance on what needs to be published as part of that transparency in relation to the contract management phase of the procurement life cycle. Now, with that, it's just approaching 3 o'clock, so I think we haven't really got time for questions right now, but hopefully you've been busily popping them in the Q&A. And so, as I said at the start, we will take those up and circulate our responses to them to all delegates afterwards, within a few days. So hopefully you've enjoyed this session. It's been a pleasure to host you, and we hope you've found it stimulating and a cause of some lively questions. So thank you very much indeed, everyone.